Commonwealth versus Acevedo.
Ms. O'Brien.
Good morning, Your Honors. Leslie O'Brien for German Acevedo. May it please the Court. Mr. Acevedo raises one challenge to his conviction for second-degree murder. He says that the jury were not instructed on the mitigating factor of heat of passion, and that gave rise to a substantial risk of a miscarriage of justice, and included in that he's argued that his attorney was ineffective for failing to raise the claim. There was abundant evidence for such an instruction to be given in this case. The defendant testified that at the time of the incident, he was being punched in the head by several people and was unable, had fallen partway to the ground, was unable to get up, although he originally tried to fend the attack off with his arms and hands, was unable to get up, feared that if he were knocked all the way to the ground, he would be in serious trouble, and then pulled out his knife and swung it several times.
Was the defendant's testimony that he never left the party and armed himself, but rather that he had the knife all night and was attacked as he left the party?
His testimony was that he had the knife with him all night, and that was the only testimony and only evidence that there was regarding when he got the knife. There was some suggestion in the prosecutor's brief that he had left the party, obtained the knife, and returned, but there isn't anything in the record to support that.
Why do you say the judge should have instructed on this particular lesser included offense? I mean, it wasn't requested.
Well, that's exactly true, Your Honor, and I really wasn't able to find any case law to say that the judge was required to instruct sua sponte. So I've concentrated on the actions of defense counsel. The defense counsel's actions gave rise to a substantial risk of a miscarriage of justice.
But could I ask you, make sure, there was an instruction on involuntary manslaughter, correct?
There was, Your Honor.
Okay, which was consistent with the defendant's theory of, I didn't even intend to do anything. I was just swinging the knife blindly, wildly. That was his claim. Not he never said, I stabbed someone on purpose.
Well, that's quite true, Your Honor, but I'd also ask you to look to the judge's instructions in response to the jury's first question, where he said that if there was no self-defense in the case, then the jurors could not return a verdict of manslaughter, either voluntary or involuntary.
And it's clear that was incorrect.
That was incorrect. And so that really wiped out any benefit that the defendant might have gotten out of requesting an involuntary manslaughter instruction.
Well, hindsight is perfect, but it seems to me, at least as of the time that the jury is initially instructed, there is a tactical reason for wanting to request, or go along with instructions, or only those instructions that are consistent with the defendant's testimony, and that still give two manslaughter options. Why muddy, tactically you say, why muddy the waters by asking for an instruction on a theory that is diametrically contrary to the defendant's version of events? I mean, it seems to me what you're doing is faulting counsel for not quick thinking on his feet when the jury question comes back for, I should change tactics on a dime and ask for something now that I didn't ask for before.
It's not just that, Your Honor. It's I can certainly sympathize that someone might not think that quickly at the end of the trial, but what I'm suggesting is that it was counsel's obligation to think of the possible defenses before the trial began, and that this defense was in no way inconsistent with anything that defense counsel had offered. It was in no way inconsistent with any of the testimony.
Well, it's no more inconsistent than the self-defense request. right?
Well, no, he said he was swinging wildly, but in self-defense, right?
But you could be swinging wildly in self-defense or swinging wildly because you've been provoked. I take it as you.
Well, that's exactly the point I'm making. And also, Your Honors, the jury clearly did not have to accept every word of the defendant's testimony. But even if they did, he said he was beaten about the head, he was in fear, he struck out. That's really, under the case law, that's reasonable provocation.
It seems to me, you try to support your claim that the defense attorney was ineffective by mentioning that he didn't even submit written requests for instructions on the substantive offense. But were the model jury instructions on homicide in effect at the time of this trial?
They were.
So then why does, what would be the, what's the harm in not requesting an instruction when we issue instructions that are exactly what the judge should use from now on? So why should the defense attorney bother to request instruction on murder, second degree, et cetera?
Because he should have known that there was this defense, not partial defense, I should say, available to the defendant.
But only on that one issue, is where he should have requested it. I'm saying that you fault him. You say he didn't even request any instructions in writing. There's really only on this one issue is the one that he should have.
I raise that, Your Honor, because I think it demonstrates that this was not a tactical decision on counsel's part. And I think in reading the various discussions that the judge has with defense counsel, it becomes clear that he's really not aware that this is a possible defense to be raised or argued. It's not a conscious tactical decision. And I think that what demonstrates that also is that I know the Court sees so many, unfortunately, so many murder cases. The reasonable provocation is a far more common defense to be raised than excessive force in self-defense. And in this case, as in the Walker case, was a so much easier defense, so much easier form of mitigation for the defense to support. Excuse me.
Are you arguing this on the face of the record and not, there was no motion for new trial, was there, in hearing?
There was a motion for new trial.
Was there a hearing?
The judge denied a hearing. He denied the motion without a hearing.
Well, okay. Well, what I'm coming to is you argued in the motion, or someone argued in the motion, ineffective assistance?
Yes.
Any affidavit from the trial counsel?
Yes, there was, Your Honor. Trial counsel stated that he did not recall why he did not request an instruction on reasonable provocation, and that he could not think of a reason for not doing so. And it's very believable under the circumstances of the case. This Court recently recognized in Commonwealth v. Walker, in similar circumstances, that the defense of reasonable provocation or the mitigating factor of reasonable provocation was the easier of the two. In order to, in accordance with the instruction the jurors were given, if the defendant used deadly force and had no right to use deadly force, he's not entitled to a verdict of manslaughter based on excessive force in self-defense. He's not entitled to that mitigating factor unless he's made all reasonable.
But here is where the defendant. I can see your point if the stabbing had occurred, if he was involved in a fight inside the bar. But here, they took the fight outside, and they walked outside. What is the evidence of heat of passion?
The defendant's testimony, Your Honor, which the jurors were certainly free to credit, was that he was initially trying to get into a car. He wasn't agreeing to mutual combat. He was trying to get into a car. When the car was locked, he went back to try to get his friend to open the car. It was at that point that the victim was clenching his fists and ran toward ran toward the defendant, and the defendant began being punched in the head by several people, fell to one knee, was unable to get up or get the people off him by using his hand, and at that point he pulled the knife out and struck out. That was his testimony. And surely, if on that testimony he had requested an instruction on reasonable provocation, it would have been given. Under the circumstances of this case, having only excessive force as the option the jurors had to return a verdict of manslaughter, the prosecution was in a position of avoiding that by simply proving that there were not all means of escape were used, that there was no right to use deadly force in response to this punching. Any of those findings by the jury knocks excessive force and self-defense out of the box. But he would still have this very common theory of manslaughter, that there was heat of passion, that this was an emotional response, that he had fear, fright, or nervous excitement in response to being repeatedly punched by a group of young men.
Ms. O'Brien, could you just help me so that I can really follow this? Mr. Eichler was – tell me who's counsel for the defendant and who's counsel for the Commonwealth, Mr. McCann and Mr. Eichler.
Yes. Mr. McCann was counsel for the defendant, Your Honor.
Okay. What I have is Mr. Eichler saying to the judge after a lobby conference, okay,
yes,
on the record, this is now in response to this question from the jury saying, in other words, other than excessive force and self-defense, are there any other mitigating circumstance, any other mitigating circumstances, okay?
Yes.
And then Mr. Eichler says to the judge, who now wants appropriately to go on the record after a lobby conference, and in further answering the question whether other than excessive use of force and self-defense there are any other mitigating circumstances that would eliminate malice, I think it's already been established that self-defense would be the only mitigating circumstance for malice here. The heat of passion in the form of reasonable provocation or sudden combat were not elements that were present here, and those theories were not instructed on. In other words, it's not as if there's a total overlooking. So the judge then says, so your answer should be no. Commonwealth, yes, Your Honor, thank you. Mr. McCann, defense counsel, you know that we've provided the jurors with an outline of all the criminal charges that are instructed plus the self-defense. Do you have a comment on that? Mr. McCann, no. I would agree with Mr. Eichler's, the Commonwealth's analysis and the court's analysis of this. I think the appropriate reading of malice as it relates to murder one, either extreme atrocity or premeditation is appropriate, and I presume the court would again instruct that they must be taking into account all of the other instructions. Now, I don't know what happened in the lobby conference, but it's very difficult to say. I don't know whether it was tactical or not, but this is not counsel not aware of the heat of passion in the form of reasonable provocation.
Your Honor, having read the entire record, I haven't
read the record, but I've read
yes,
the critical conference with the judge in response to that jury question is troubling, because the jury, as often happens, they've gone through everything and they're now focused. And there's a very focused discussion. Now, one may or may not agree with the Commonwealth that the heat of passion in the form of reasonable provocation or sudden combat were not elements that were present here. I take it that the Commonwealth is saying there wasn't evidence to support such an instruction.
The Commonwealth also argued that there was no evidence to support self-defense and objected to an instruction on self-defense.
No, I understand that. So, but now they focused on this, and I take it there must have been some discussion in the lobby, which we don't have, but with a very experienced trial judge, about, there are some other ways that you can go about this, and the classic is sudden combat, heat of passion.
Your Honor, the judge at one point says that he doesn't recall whether the jurors were instructed on heat of passion, and defense counsel just stands silent at that point.
But it seems as though the import of what the Chief was talking about was that it was a tactical decision.
But if it is a tactical decision, Your Honor, it's completely unreasonable. It's completely unreasonable to leave the jurors. It's clear that defense counsel wanted the option of manslaughter there.
He wanted to ride one horse into battle. Isn't that a perfectly reasonable decision? He didn't want a jury instruction that conflicted with the defendant's testimony.
But what I'm saying, Your Honor, is that it doesn't in any way conflict with the defendant's testimony. I know the prosecution has argued that there would have to be intent to kill for the defendant to have the benefit of a manslaughter verdict based on reasonable provocation. There's nothing in the case law to say that. The case law says that malice is negated by reasonable provocation.
So whatever. Can I just ask you one other thing? In light of that, I'm a little concerned, frankly, about trial counsel's affidavit. Now, I understand that you asked for a hearing and the judge denied a hearing.
I did.
Now, trial counsel, I presume, could have said, I've been informed, it's a very short affidavit, I'm an attorney, I've been informed, we're not instructed in the defense of reasonable provocation, that I did not object. I do not recall having any tactical reason. You correctly represented what he said. And nor can I think of any tactical reason. An affidavit from counsel that said, to be frank, I just didn't realize that that was available to me. I mean, that's your argument here, that he just didn't seem to be aware that this was a defense. Now, in the face of that transcript, to have counsel at best saying, I don't recall, that's okay, I don't recall, but that's a little different than saying, let me be frank, I took the bar, just missed me.
Your Honor, but I'm saying that if it was a tactical decision, it was completely unreasonable. And I'm also saying
that's a different standard.
I've argued both.
Yeah.
And also, I'm saying that that defense counsel's statement that he doesn't recall having a reason, if he had a reason for leaving out this very common, often used mitigating factor when he wanted the jurors to have the ability to return a manslaughter verdict, if he actually had a reason for doing that, surely he'd remember it.
Well, maybe.
Thank you, Ms. O'Brien.
Thank you, Your Honors.
Mr. Kirk.
Chief Justice, Kevin Curtin, Assistant District Attorney for Middlesex.
Would it have been error for the judge to have given the requested the instruction that the counsel now says should have been given?
There did not seem to be really enough evidence to support it, and everybody clearly did agree in that portion of the transcript that the Chief Justice read from, which is in Volume 8, pages 4 to 5. It's very clear that he knew that the theory of reasonable provocation and sudden combat were available because he said that those things weren't present.
Well, what about the evidence that defense counsel just recited to us? We must, for this, I believe, look at the evidence in the light most favorable to the defendant for the omitted instruction. And so taking the evidence as defense counsel just summarized it, would that have been sufficient to support the omitted instruction?
I really don't think so, even if it had been requested. Now, I don't think I disagree with the Court's initial suggestion that the standard that you're going to employ is whether or not the evidence would have warranted the instruction if it had been asked, because, of course, this is one of these waived issues at trial that can't be resurrected and was certainly not resurrected. Moreover, the principal defense clearly was self-defense. Now, had the defendant testified in a different manner as to his fear, and then possibly it might have been tried had he testified differently on a theory of reasonable provocation. But the defense attorney knew that he was stuck with the defendant's own pretrial statements which were inconsistent with provocation. He knew he would then testify, and in fact, his testimony was inconsistent with provocation. He told police that that the victim didn't hit him. He told the police that he was not angry, that he didn't intend to stab anybody. He said that
he was not angry, but
Yes.
he also told them that he was set upon by 3 or 4 people who were punching him, attacking him. He didn't think he was going to be able to get up off the ground. I mean, that's sudden combat. Why isn't that sudden combat?
It's not sudden. It may be combat, but it's certainly not sudden. It was.
But he's wait. He's backing away. His testimony now. I'm not talking about your theory of the case. I'm talking about his testimony. He's trying to get in his car to get out of there. The car is locked. He
So
asked
he
somebody
said-
else to open the car.
That's not what his friend said, but he did say that.
All right. We're looking at the evidence in the light most favorable to the defendant now.
I don't see why. It's a motion for new trial. It's a waived issue. You shouldn't. You shouldn't look at
Mr.
it.
Well, no,
Mr. Curtin, can I ask you about...
we were just talking, excuse me if I can just finish, we were just talking about whether, if requested, the jury instruction would have been necessary.
Fair
That's
enough.
what we were discussing,
All right.
okay? So if you want to switch gears, we can switch gears. I agree with you.
Right.
That, in fact, the issue has been waived. So it really comes up in the context of ineffective assistance of counsel.
Right. And there's no way that this was ineffective assistance of counsel, because it's very clear that he knew of the availability of this theory. He had problems with asserting this theory because the defendant's own pretrial statements were inconsistent with them. He said that he struck out blindly, not intending to harm the person who presumably provoked him.
What do you do with his affidavit, though, which, as I recall, says, I really don't remember. I don't really hold I don't hold any fault on that because he's probably had a lot of trials. But then he goes on to say, I don't know why I wouldn't have done it. When you're faced with this transcript portion that seems to say he's made a conscious choice in not doing it.
Well, I think that the way to handle that second portion of his affidavit
Is to say the judge looked at it and rejected it, perhaps, saying, here I've got concrete evidence contemporaneous with the trial.
Right.
This defense lawyer is saying, yeah, I know about this.
I think you're right, Your Honor. It's hard to give that portion of his affidavit much weight at all.
Yeah, and then so then you go into the analysis of, if the evidence was debatable on the point, even though we have to look at it closely, we better not go for it because it gives the jury a clear prong to convict this guy on where he's going to get a perhaps 15, 20-year sentence.
I think which would have been catastrophic.
Which would have been catastrophic. So let's go with what we got and shoot all the marbles. So on that analysis, the appeals court, that's about what the appeals court says.
I think the appeals court was right. And if you
Mr.
analyze...
Finish your answer to Justice Glaney.
And trial counsel was right also in adopting, that strategy because he had 2 ways of getting an acquittal. Justification by self-defense and also that it wasn't an intentional killing. So he has both of those. He has a fallback position of manslaughter, which was justified by the evidence, arguably. There were slash marks. Maybe he wasn't using deadly force, even though he was using a knife at the time that he was supposedly being punched. The jury could well, if they wanted to compromise, return a verdict of manslaughter.
Now, what cuts against us, of course, is his affidavit where he, it's kind of mushy. I mean, why doesn't he say, I discussed this with the defendant, and the defendant agreed to this strategy? I mean,
there's no evidence of any such waiver of privilege by the defendant.
Well, it's waived the minute he files the motion.
It may well, yes, but certainly there was an opportunity for that type of an affidavit to have been filed. And the fact that it wasn't, I think, tends to shows that you really can't give it much weight.
Sure. Mr. Curtin, I am concerned. I understand the waiver and the circumstances in which we look at this, but I am concerned that there seems, at least in my very quick read of the defendant testified, of course, that of the sudden combat theory. I mean, sudden combat and/or provocation. I mean, in the circumstances. In the circumstances of this case, the two almost meld in the sense that self-defense.
I think I understand what you're saying, but I would take the different view. I would say that in the abstract, the theories may sometimes meld or may be seen dispelled. But under the facts of this case, where he said that it wasn't an intentional stabbing, This is a perfect case to show that they don't.
But what he's really saying is, these people came at me suddenly. I was provoked by them. They were all on top of me. It was just they were all on me, and I was trying to get them away from me.
Yes.
Now, you got two pieces there. They coming at me,
Right.
and I'm trying to, and there are many of them, and they are, attacking him pretty badly.
That's right. Doesn't that sound like self-defense?
Well, it also sounds like provocation.
I don't think it sounds like provocation. What sounds like provocation is she told me she was having an affair, and I lost control and killed her.
That's not sufficient. That's not sufficient, so you can think of another one. But there was something.
But there are others, but they're not like this. There are instances of reasonable provocation where someone loses control of their ability to reason and flies off the handle and kills somebody. There's plenty of cases where that is a good theory of defense.
No,
or
I
of
understand.
mitigation.
It's stated differently. Where somebody has been provoked for reasons that we think are legally sufficient, they have really been the attacker.
Well, that's very interesting.
In other words, they've gone after somebody, they've done something and said, I was so angry, and we've said, as a matter of law, you were sufficiently angry such that it's a defense.
Adequate provocation in law. And there are important policy considerations for limiting that.
No, I understand. But
But isn't it reasonable provocation or sudden combat?
Or sudden combat, absolutely.
So that you don't have to be the provocateur.
Correct.
If there's sudden combat and a person, say, suddenly is engaged in a fist fight and he picks up a weapon and uses it, as this court said 150 years ago in Webster, that will be manslaughter.
Well, isn't that exactly what happened here? That's what happened. He's engaged in a fist fight and then pulls out of his pocket, i.e. picks up a weapon and uses it all of a sudden.
Well, here's a case. However, this is a case where the defendant took advantage at the outset. And I think that the judge was well within his discretion in looking at all the evidence in this case and the lack of consistency with the defendant's story, and determining that there was no substantial risk of a miscarriage of justice because he had the knife with him. The way that he used the knife shows that he acted with malice and not because he lost control or his use was stealthy. It was inconsistent with a state of mind where he's trying to get people away. Nobody saw it. He's not showing it. He's got a knife. You don't hear him saying, I have a knife, get away from me. What you have is a case where he's secretly using a knife that somehow he was able to open at a time when it was clear that he was going to be engaging in a confrontation. It's consistent with the use of deadly force by stealth. The force was inconsistent with the manner in which a theory of a reasonable provocation would reasonably sound. I just couldn't help it. It was not a heat of passion that occurred shortly after the provocation. This was an ongoing problem that occurred 45 minutes before the defendant even came back. This is not someone grabbing a victim from behind by the throat.
Mr. Curtin, the defendant takes issue, and I think I understand your theory with that. So much of your brief suggests that he left the party the theory was that he, relying on the Amaral case, that he left the party, went and obtained a knife, came back, picked a fight.
Yes, and I filed a 16L letter in the appeals court, which may well be with the papers. I think that was probably stretching it because there was no direct evidence, certainly, of that because it only came from the defendant.
Well, I'm looking at your brief here, so.
Yes, there was a 16L letter that I filed in the appeals court. However, there was inferential evidence based on all the circumstances, possibly that you could surmise that he probably got it. But I don't think that there really was solid evidence from which you could have a reasonable inference that that's when he got it. He testified that he had it the whole night. Now, it's inherently improbable, of course, that someone's going to carry a knife like this so loosely in a hoodie pocket all night long when he's partying and doing this and that. But I don't think that even that is probably enough.
Could you describe the knife? I assume it's
just before
described.
we finish that, I mean, I have your brief not in the appeals court, but the brief that was filed here. So if there are corrections that should have been made, would you just make?
Well, it was, Your Honor. I didn't specifically argue, although I think that it was at one point in the argument section as opposed to the facts section, something did sneak through as I revised it.
Okay, well, just get us whatever.
But we don't need that.
And what kind of a knife is it? I think you said a butterfly knife, but I don't know what a butterfly knife is.
A butterfly knife was the evidence. And so I think that the court would have to,
Is it in the transcript, explaining it?
There is not a great deal in the transcript.
I take it, though,
details.
that a butterfly knife is one that you have to open.
Yes. You have to, it's not a stiletto, it's not a switchblade. You have to open it. Whether it can be opened with one hand while supposedly you're fending off other people is
But the blade
suspect.
is a typical knife blade. I mean, it appears to be almost two-dimensional. It doesn't flare out. It doesn't have two blades, does it?
I see. No.
It's not a V-shaped blade.
No. There's nothing to suggest that it's anything other
Like a
than the type
jackknife.
the type of folding knives that open in a certain way,
All right,
like a butterfly.
the knife's in
and flash
evidence,
the back.
isn't it?
Sorry?
The knife is in evidence.
It was not in evidence. The defendant threw it
Oh, that's right. He threw it over the bridge or something.
So you could carry that type of a knife easily. These sweatshirts have big pockets. It'd be easy to carry. That's why I was wondering when you made the point that you wouldn't carry it around. I wondered if it was something other than a typical jackknife, which is easy to carry around in a big pocket.
Well, that's sufficiently arguable that it's not necessary to the Commonwealth's case to insist that it's a reasonable inference.
Could I ask you to address, assume that I, follow you, that at least up through the original instructions to the jury, there's a reasonable tactical decision being made here. I would like you to address, though, when the jury comes back with that question.
Yes.
I mean, counsel are obviously alert to every clue that comes back in a jury question. And the clue that came back from this jury question was pretty, it was not subtle. It was pretty clear they weren't buying self-defense, but that they were looking for something else to reduce it to manslaughter.
See,
At that juncture,
yes.
shouldn't counsel in this, and that's when this discussion occurs, have been a little more alert to my strategy is not working, and I'd better do whatever possible to come up with something else?
I don't think so. I mean, how much weight can you put into it? We don't know whether it's one person who over the weekend may have seen something on TV. I heard there's something about if you kill someone in the heat of passion, it's manslaughter. Why aren't we hearing about that? Isn't there something else? I don't think that the question gives you what insight into the minds of the juror. What gives you insight into the minds of the jurors is the verdict. And the same facts that, if believed by the jury, would have might have arguably amounted to reasonable provocations, that he was in great fear, principally. Those facts, if believed, would also have given rise to the defense of self-defense, and the jury rejected that. If they believed the evidence that would have been necessary to establish reasonable provocation, which
No,
the
because
only
if
evidence
somebody
really was.
says, let's assume that, one version of the facts is, again, gets back to the discussion that you and I had, whether in the circumstances of this case there's any difference between provocation,
Yes.
sudden combat, and self-defense. And I just haven't, frankly, worked that out.
The key here is that the defendant gave pretrial statements and testified that he didn't intend to kill somebody.
Well, but your argument. I want to touch about that anyway. Your argument is that the defense attorney properly didn't request the instruction on provocation because that would contradict the defendant's own testimony that he didn't intend to kill the victim. But the defendant argues that that would be so only if the law were that reasonable provocation mitigates only the most egregious form of malice, intent to kill, and not the other two forms. What do you say to that?
That's really beside the point, because
It's not beside the
Why?
point.
Why
It's
is it
It's a
beside the
defense to premeditation.
But the problem is
He's
that
saying, I didn't premeditate. Okay, he didn't premeditate.
And he wasn't convicted of murder in the first
He was-
degree
or
either.
he didn't.
So, yeah.
Correct.
Yeah.
But-
And you can be, certainly you can premeditate even if you've been provoked.
Okay, but why isn't that relevant to the other two forms of malice? Intent to do grievous bodily harm, and you know what they are, and intent to act.
Well, it is relevant. All the
Okay,
fact that
and
he
the
was in
defense-
fear is relevant to whether he intended to commit a battery.
But it does it intentionally contradict the other two forms of malice?
Well, what contradicts the theory of reasonable provocation is not so much a theory of self-defense being also advanced. What contradicts a theory of reasonable provocation is the evidence in the case. And everybody knew that the evidence was not that of reasonable provocation. The defense was clearly self-defense.
But now you're switching gears, because you make the argument over and over, as I recall, that the defense attorney action was proper because the defendant's own testimony contradicted that he didn't have an intent to kill.
Right.
But you're conceding that the defendant's testimony doesn't contradict the other two forms of malice. You're saying other evidence.
Well, I'm not sure. What I would say is, rather than doesn't contradict, I would say is consistent with. The defendant's story is consistent with involuntary manslaughter. It's not consistent with voluntary manslaughter by heat of passion after a objectively reasonable provocation that this court is going to say is adequate in law to justify a killing.
Thank you, Mr. Kirkman.
Thank you, Your Honor.